Under the Speaker's announced policy of January 7, 1997, and under a previous order of the House, the following members are recognized for 5 minutes each. Ms. Roz Lettinen from Florida, Mr. Foley of Florida. Under the Speaker's announced policy of January 7, 1997, the gentleman from Texas, Mr. Paul, is recognized for 60 minutes as the designee of the Majority Leader.
Thank you, Mr. Speaker. I ask unanimous consent to revise and extend my remarks.
Without objection, it's so ordered.
Mr. Speaker, we all know that when we come here to the Congress, the only oath that we take is to the Constitution. Yet, I think very often we here in the Congress are careless about the Constitution and that we do many things that do not comply. A recent article in the New Republic calls attention to this subject and more or less ridicules and downplays the importance of the original intent of the Constitution. Today I would like to discuss that article and reiterate the importance of the Constitution and the reason why we must have the rule of law rather than the rule of man. The principle of original intent which underpins the Constitution is under serious attack. This is nothing new, but there is now a much more open challenge to this principle than ever before. A case in point is the New Republic article of June 23, 1997, called Unsound Constitution, where George Fletcher, a Columbia law professor, viciously attacks all constitutionalists. Vicious because he uses modern-day McCarthyism to tie any individual defending the Constitution and its original intent to all Oklahoma City-type bombings. In this very significant article, voicing a strong anti-constitutional viewpoint, Fletcher uses McVeigh to discredit not just the misdirected and ill-advised promoters of violence, but the entire American Revolution and the goals set by the founders. Failing to consider that McVeigh flaunted property rights and the personal liberties of innocent people, Fletcher nevertheless uses him as an example of a true defender of the U.S. Constitution by using some of McVeigh's quotes. This New Republic's article falsely equates the bombing of innocent people with those who strictly interpret the Constitution, a document which Fletcher describes in quotes is fundamentally wrong, close quote. Professor Fletcher goes to the heart of the matter. He openly attacks the principle that rights are, quote, vested in the people, close quote, and claims it was this principle that McVeigh used to justify what he did. Painting with a very broad brush, Fletcher hopes to dispense with the entire Constitution and its protection of individual and minority rights. If the New Republic, Fletcher and his allies get away with this preposterous assertion, it will further undermine the principle of individual rights. Fletcher claims the greatest myth surrounding the Constitution is that the people are sovereign, and that sovereign people will inevitably engage in actions like that of Timothy McVeigh. Equally threatening to the big government theorists is that this concept of sovereignty, with rights being left to the people, would justify jury nullification, a horrible and dangerous thought as far as they are concerned. Jury nullification allows acquittal when a juror refuses to vote for a conviction for moral, constitutional, or even racial reasons. Yet jury nullification is a tradition of long standing, not only in American law, but in the British law as well, dating back to the Magna Carta in 1215 AD. But Fletcher refers to jury nullification as, quote, obstruction of justice, close quote, and equivalent to overt sedition against the government. Fletcher is consistent and even condemns the black left for endorsing this notion that juries have some type of veto power over bad legislation. Several professors from the left now advise that jury nullification can and should be used in certain cases to repeal unjust laws when they are specifically targeted against African Americans, such as with drug laws. Obviously, this veto power of the people should be used to nullify unjust laws in general, not just against black Americans. What the New Republic and Fletcher failed to recognize is that this is a technique that could have been successfully used in the 50s and the 60s in the civil rights struggle, with a lot less violence resulting. The thought that the people retain enough sovereignty and authority to veto our legislative bodies threatens Fletcher and other big government proponents. The Fully Informed Jury Association, a movement of well-known significance today, must be having an impact on our society, or why would we all of a sudden see a systematic attack on this concept? This attack is not limited to the New Republic. The New York Times has chimed in as well, expressing deep concerns about this dangerous notion that people ultimately have a say about the constitutionality of legislation. If Fletcher had his way, he would argue that the people's only recourse to bad law is strictly limited to the ballot box while excluding the jury box. The boldness with which Fletcher attacks the original intent of the Constitution is frightening, but also helpful in getting us to understand exactly what the goal is of the supporters of the new Constitution. The fundamental flaw in the old Constitution, according to Fletcher, is, quote, the original republic, the one for which our forefathers fought face to face, hand to hand, exists only in the minds of academics and fundamentalist patriots. The Republic of 1789 is long gone. It died with 600,000 Americans killed in the Civil War. That conflict decided once and forever that the people and states do not have the power to govern their local lives apart from the nation as a whole, close quote. He argues that the original republic died and deserved to do so because of its flaw in dealing with slavery. But how can this single admitted flaw be reason to reject all the worthy parts? This is only an excuse to reject the entire concept of the doctrine of enumerated powers and the idea of the rule of law in contrast to the rule of man. And all this is to be accepted as fact because this flaw in the concept of individual rights with regards to slavery supposedly led to the irrational acts of McVeigh. Fletcher laments the absence of the word equality appearing in the Constitution, a word, of course, that is dear to the hearts of all socialists. Clearly, it's economic equality that he is talking about. He complains that in 1789, equality was less important than the fear that a federal government might infringe our liberties. What Fletcher doesn't realize is that the large majority of American people are still fearful of that very same thing. What actually scares the anti-constitutionalists like Fletcher is that today there is once again a growing number of Americans who fear and distrust the federal government and yet don't relate in any way to the McVeighs of the world. His only hope is to discredit the constitutionalists and the entire principle of the doctrine of enumerated powers by slanderous innuendos associating them with violence toward innocent victims. Fletcher makes McCarthy look like a saint. Fletcher boldly now refers to the new Constitution, the one that shapes and guides the national government. And unfortunately, in a real sense, I am fearful that he is correct, that a new Constitution, or at least the way the original one is treated by Congress, the courts, and the administration, prevails and guides most government action today. Up until now, it has been subtle and seductive, but the boldness with which Fletcher and the New Republic tries to bury the old Constitution should alert us all to what is happening. Fletcher argues that the notion of organic nationhood replaced the sovereignty of the people. That, I'm sure, a lot of Americans were not aware of. And the U.S. evolved from an elitist republic into a democracy, so he says. Jefferson and Franklin would be shocked. This idea, he claims, was not acceptable by the founders since they lived only for the moment. He talks as if truth and liberty were not meant for the ages. This proposition, he argues, allows, quote, the sustained campaign to convert the elitist Constitution of 1789 into an egalitarian Constitution that bases democratic rule on the majority of all the people, close quote, thus endorsing the dictatorship of the majority while destroying the concept of minority rights. Fletcher clearly here endorses the very flaw, limited as it was, that permitted the acceptance of slavery in the original Constitution, and that which he pretends to disavow.